If you want to talk, please go outside.
Judge,
Hold on. So we're on the record. Cause number.
Contempt of court is no joke. McLeod is facing serious consequences. 93 days in jail, a $7,500 fine, or both. The judge is laying out the stakes, and McLeod's casual response suggests he doesn't grasp the gravity of his situation. This is a masterclass in how not to handle a courtroom appearance.
253-4377, 2505-146. I think that's all we have here, right?
Yes.
Yes. Okay, so guys, for the record, please announce yourselves. State.
Anna Eady, E-A-D-Y, for Mr. Wiggins.
Nathaniel Munier spelled M-U-N-I-E-R, also for the defense.
So hold on, before you get into anything, state. You wanted to bring something to the court's attention.
Yes, Judge. So we had received a call that Mr. Wiggins was in violation of the protective order that was in this VPO, and that he was reaching out to the complainant witness in this case. We have checked the jail calls. Those jail calls show that since March 24th, which is, of course, after the October VPO, since just March 24th, we have 293 calls made to the complainant's phone number. Just yesterday, we had, I believe, 28 calls to that number as well.
McLeod is invoking his constitutional right to self-representation, but the judge isn't buying it. The Supreme Court has ruled that self-representation isn't a free pass to disrupt proceedings. McLeod's history of defiance, rejecting court mailings, filing nonsensical documents is about to backfire spectacularly.
So in one day, you're saying he made how many calls?
So yesterday, he attempted 28 calls to the complainant's phone.
So, Judge, I'm going to preface this conversation with, Miss Edie texted me about 10 minutes ago, so I came up on short notice on this. But my understanding is that there's no longer a protective order in effect, because it's been long enough that the protective order...
There's an order for him not to have any contact with her.
Are those part of his bond conditions?
Yes.
My client's not on bond.
Well, he is not supposed to have any contact with her whatsoever.
I understand, Judge, but the way that this court and other courts in the county have structured those conditions have been bond conditions, which my client is not on a bond. He is in custody. He has not broken.
I have ordered him, even though he's in custody, not to call her.
I understand, Judge. Assuming that he had violated some form of a court order that is not a bond condition, I believe the appropriate remedy would be contempt, and which would be a separate criminal proceeding. At the same time, for Ms. Edie talking to me today, it sounds like that the court was going to order ag-seg in the jail, so the formal...
The only way that we can revoke phone privileges on someone is ag-seg.
Yes, Judge. My issue with that is it's a hammer when a scalpel is needed. So while I understand that the district attorney's office has alleged that my client is called a victim in this case, there's no protective order in place. The bond conditions are not in effect because he's not on bond. Thus, no crime has taken place. And third to that, Judge, if he's to move to ag-seg, he would not be able to make any phone calls, not just to the victim, but anyone, including counsel, which while we are here on a misdemeanor, he is in custody on a felony and relatively serious felonies. And
The
not
only
being
way, okay.
The judge is detailing McLeod's pattern of behavior, refusing mail, filing bizarre legal claims, and disrupting hearings. This isn't just about one missed court date, it's a pattern of contempt. The judge's patience is wearing thin, and McLeod's right to self-representation is hanging by a thread.
I understand your plight.
Yes, Judge.
But there are other remedies for you to be able to communicate. Letters, in person. But the only way for me to be able to ensure that the complaining witness is not called is to put him in segregation. That's the only way.
Judge, the problem is nobody would be able to call, including our office as well as his felony attorneys. Letters through the jail are notoriously slow. A letter to my mother who lives in the same city takes 4 days. Add in the jail, you're taking over a week.
I'm willing to put him on the docket one time a week so you guys can have contact.
Which the problem is, Judge, we would no longer be able to have any form of private contact, and that would only take care of the misdemeanor and not the felony. And not to be impolite, Judge, Him having conversations with us are saying, hey, what's going on with the felony? And any jail visits that take place in ag-seg are actually recorded. They're notified by counsel going through the door that those calls are being recorded.
I don't have any other option to not
Well,
prevent
Judge,
phone calls.
this would violate my client's 5th, 6th, 8th, and 14th off the top of my head constitutional rights. Right, self-incrimination because every conversation is going to be monitored going in and out of the jail because they're going to be recorded via jail visits. He will no longer be able to have private visitation inside the courthouse.
You can pull them out. You can have private visitation in the rooms there.
It's not about me, Judge. It's about felony court is a serious issue, but that's the.
Why are you worried about felony court?
Because that's why he's in, Judge. Then
That's also in because of ours. Our bonds are at $60,000.
I understand, Judge, but the reason that this is taking as long as it is and it's been taken as serious as it is because he's in custody on a felony. And this court making him to where he cannot participate fully with counsel is.
There are other means for you guys to participate, but I've ordered you not to have contact with her. You've called her now over 300 times. I don't understand why you.
And there it is. The judge revokes McLeod's right to represent himself. This is a rare but necessary move when a defendant abuses the privilege. McLeod's actions have crossed the line from eccentric to obstructive, and the court is stepping in to restore order.
I missed the last statement.
The only way that I can prevent him from making 300 phone calls is to put him in another wing.
I was going to talk with the DA, and obviously, if my client's making these calls, and that's an if, he's dialing a single number, the jail's numbers can be easily blocked. I've done it on my cell phone numerous times when I've changed cell phones. Over the weekend, last weekend, I had 15 jail calls from one client. And as annoying as that is, it's very easy to block it on your cell phone. And I assume the victim could do the same. I have not heard anything from the state.
Tell the victim what to do, Nathan. I'm not going to say, can you please block your number so we can't call you?
The least restrictive means, Judge, strict scrutiny dealing with constitutional rights.
No other way to prevent him from making phone calls. I have acquiesced to you guys before, and I have admonished him before. Please don't. We put you in SEG last time. You were there a month. You came here begging and pleading, I'm not going to do it, I'm not going to do it. And now we have 300 phone calls. So I don't know what else to do. But now back in ACSEG.
I'm going to sprinkle the word allegedly to the phone calls because it's the kind of thing where records would exist that have not been provided to the defense by the state.
Do you have the records?
Well, I mean, I have them. I just have to I have to do the forms or get them up with the forms. Yeah.
Okay, so let's set up for a formal hearing because I don't want. You're right. I don't want to give you state the benefit of the doubt without him actually or Anna actually seeing it and seeing that the phone calls were actually made. So let's set up for a formal hearing. How soon can you get him the evidence?
Attempt to downplay his actions as junk mail is a desperate move. The judge isn't fooled those mailings were clearly marked with sovereign citizen rhetoric. This is a moment of reckoning. McLeod's defiance has consequences, and the court is done